Good morning, everyone. Just putting in our phone numbers here so I can pin it. Okay, good morning. Bonjour. Railways, bonjour, bonjour. Garden Ford, good morning. Good morning, Amy. Honor, good morning. La Tracy, good morning. Arlene, this is Arleanne on YouTube. Good morning. Welcome, everyone. From Facebook, YouTube, Instagram. Thank you for joining. If this is your first time, welcome. My name is Aisha Chidole. I'm an immigration lawyer here in Atlanta, Georgia, but I represent clients all over the United States with their immigration matters. We handle a variety of cases. We handle family based immigration, so that will be your marriage based cases, your consular process cases, like your family, parents, children, siblings, fiance visas, removal of conditions. We also handle humanitarian based cases, so VAWA cases, victims of abuse at the hands of a relative US citizen or green card holder, T visas, victims of labor trafficking or sex trafficking, U visas, victims of a serious crime here in the United States. We also handle removal proceedings. If you are in deportation proceedings, we handle those as well, and some bond work. So if you'd like to schedule a consult, call our office, 678-325-1037 or 678-233-2170. You can also comment yes at some point during this live, and one of my team will reach out to you to see how we can assist you with whatever you're going through personally. So, someone is saying they can hear me. I don't know if you all can hear me. Hopefully, you can hear me. Good morning, Sherva. Someone says, "Are you live on TikTok?" No, I'm not. I really hate TikTok, by the way. I really, really hate TikTok. I mean, I have my auto posts that go from here to there, but personally, like, I don't think I've been on TikTok in like 2 years. I hate TikTok. I know people say go on TikTok. Um, but no, I'm not live on TikTok. So, hopefully you can stay on Instagram live. Um, Good morning, Dre. Good morning, Miss Tisha. I had a consultation with you and you're the best. Oh my goodness. Thank you so much. I appreciate that. Um, okay, let's see what else we got here. Okay, you can hear me. So what questions do you guys have? What questions do you guys have? Today there's no breaking news today. Well, other than what I talked about yesterday, which really is for those of you who are outside the United States that want a consular process outside the United States and Africa. Of the 50 countries that are in Africa where they used to consular process for cases, here in the U.S., they've basically reduced that to 20 countries where you would have to travel to go do your visa processing. I have that on my post with a list of the 20 countries, so you can view that. Um, Someone is asking, how long does it take between a master hearing to an individual hearing in New York court? There is no such thing as a timeline of how long it takes. It's up to the judge and their own schedule. For some people, it can be 2 years. Some people are scheduled out till 2028. Some people are scheduled out to 2027. Some people are scheduled out to 2026. So it really, really depends on your judge and their own caseload. There's no standard from a master hearing to an individual hearing. And for those that want to know the difference, a master hearing is when you first get a notice to appear in front of an immigration judge, where those hearings are typically shorter, and it's basically to determine if you have anything to plead, if you have any options, basically, that would keep you here. And some judges will ask you to have a written pleading by X date, or whatever it is, or they'll continue the case or come back for another conference master hearing. And then the individual hearing is really your real trial. Like, that's where you're going to be examined and questioned and asked about whatever relief is seeking where witness testimonies or evidence is presented. So that's really the core trial. Yeah. I'm a U.S. citizen and I have two underage kids in the States legally. I'm from Nigeria. Is it okay as I've already filed for my kids and will their cases be adjudicated? It is okay to file for adjustment of status. I've talked about that every single day that I've been on live. Understanding that, there are certain things because, they're reminding them of their discretion. They are going to be stricter when they're looking at certain things, which would be, i.e., public charge or economic um, 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 contribution to the United States. For your children, they're minors and underage. So I don't anticipate there'll be any issue with them because, again, they are going to experience extraordinary hardship, consular processing, because there is a visa ban outside of the United States for Nigeria. And also, they are underage. So, you're their father and you are a U.S. citizen. So I think it should be good, but you should be prepared, with everything that you need to prepare to prove that they're your children and, all of that good stuff. Son says, girl, Jay's the best attorney. I just love watching you every minute. Thank you so much. Good morning, Carrie. How are you? Okay, let's see what else we got here. So I see some questions, but it's like a continuation of another question. So I can't, I'm not able to answer it. Good morning. I didn't tune in yesterday, so I was wondering if you heard anything about the 79 countries pause. I filed an I-130 for my son in 2025, so I'm just waiting to hear back from USCIS. No, they have not removed the public charge pause yet for the 75 countries. That said, your I-130 should not have any impact on that. Your I-130, they should be able to make a decision whether there's a pause or a ban, and that's why, when we get any results from these countries here on United States side, I like to post it so you can kind of see what's happening with USCIS. As you guys know, they're approving those I-130s. Remember, also, if you're from the 75 country pause, as long as you're not also overlapping with the ban, you typically, they will fully adjudicate your case to the end. They will fully adjudicate your case to the end. Using Jamaica, for example, since, we do serve a lot of Jamaican clients, they do have a 75 country pause outside of the United States, right? So like if you finish with your consulate outside of the United States, they will administratively hold your case because of that pause. But here in the United States, they're going ahead and approving those green cards, those work permits, those I-130s, I-360s, 751s, and for whatever it is that you're filing for, basically, here in the United States. The countries here that have a delayed processing are going to be people from the 39 countries that are banned outside of the United States. So inside of the United States, they have a delayed adjudicative hold on their cases where they're doing like a thorough review of those cases. But, we started to see some of those cases get those I-130s approved. In interviews, officers will generally tell us, we'll approve the I-130 now, and then we're just waiting for directives before we can approve the 485. Okay. Can I file for my mom in Nigeria as I'm a U.S. citizen? Would that be okay? Would it be an issue? Or what would the issues be? So you can file for your mom. They will make a decision on the I-130. If they approve her, then they're going to move you to the National Visa Center. My recommendation is to delay your process when you get to the National Visa Center, pending when you get approved and what the situation is. So since you've not started for yet, I would say that it takes about maybe like 6 to 13 months to get the I-130 decision for her as your mom, in Nigeria. Once your case is decided, typically what happens is they'll move the file over to the National Visa Center, and that's when you do like your documents up, fill out her visa application, and also do your I-864, your financial affidavit of support. Strategically, what I would recommend, to most people is to delay that, because you basically can delay that for as long as you want. So basically examine where the band stands when you get to NVC to determine how much you want to delay that, because once you finish NVC, it takes about 2 to 3 months to get documentary qualified, right? And then after you get documentary qualified, you get placed in queue for an interview, which, in the past, I would say Nigeria was taking about a year plus. We actually have one. It took like, for her interview to be scheduled, about 9 months, which is, to me, is early for Nigeria, right? But it's also because the visa processing is obviously less. But what I'm saying is that I would even wait when you get to NVC to see what is happening at that point to decide, should I do the documentary qualify or not? Because understand that even if you wait, your I-130 will not expire. You just want to be able to let them know that I still plan to pursue this. I am just waiting for the ban to be lifted. But that way she's already in line, and she's finished the first process, which is the I-130. And you're just waiting for them to lift the ban so that you can then place her in the queue to be scheduled for a consular interview. Does that make sense? Okay. I just wanted to know what happens if my daughter turns 18 before we get issued an immigrant visa. Her case was expedited, but we haven't received an interview letter yet. Documentary qualified January in the Philippines. This is a really good question, and I think one that a lot of people confuse about the age when the child moves from immediate family member to family preference. As long as the child is under 21, she's not going to age out. She's not going to age out. So if she's just turning 18, she still has a good 19, 20, 21, a good 3 years, before she ages out. And even at that, there's something called CRBA, where they lock in your child's age based on when the I-130 got approved. So your child should be good. So again, for those of you who it's not clear, if your child is under 21, when you file for them, not under 18, under 21, that child will be considered an immediate family member, not a family preference member. And what is the difference between an immediate family member versus a family preference? An immediate family member means that visas will always be available. There's no waiting. There's no waiting for the visa bulletin. If you age out and you're over 21, then you're subject to the visa bulletin and when they're processing those cases. So again, immediate family, no visa bulletin, visas immediately available. And family preference, you gotta wait. As long as you're a US citizen and your daughter is under 21, she'll be good. Because that's one thing you didn't mention. You didn't mention if you're a US citizen or a green card holder. Now, if you are a green card holder, she will be in the family preference category, but she still will have 3 years to age out of, F2, which would be the category, and which is current right now. So, okay. Okay, someone says, in your personal opinion, will this ban be lifted during this presidential term? Honestly, I don't know. I honestly cannot tell you. Unless I worked for the administration. I have no opinion, because my opinion doesn't matter. Like, what I think doesn't matter. What matters is, are they going to lift it or not? So I truly don't know. And I never want to give any assessment that doesn't make sense, and that's the way we as attorneys think. I like to deal in facts, not what my opinion is, because my opinion really doesn't matter at the end of the day. Like, I could say my opinion is we should have a different administration, but it really doesn't matter. It's who they vote for, who the people who are US citizens vote for. So sorry, I can't give you one, but we will be watching. And if anything changes, I will definitely let all my audience know. Okay, so Jane, you're confirming that your husband is a US citizen. So definitely no visa bulletin required. She is an immediate relative until she turns 21. As a US citizen, what is the maximum age to file for underage kids who reside in the US who came legally. What I just said, 21, 21. As long as you're under 21, you can file for them as long as you are the biological parent filing for them. If it is a step parent filing for them, that step parent relationship had to have been established before the child turned 18. So, meaning they have to have married the biological parent before they turned 18. Once they marry before they turn 18, the maximum age will be 21. If they married after they turn 18, they cannot file for them. Okay? Guys, my nose is so blocked today. We have, I was like rejoicing that no more pollen, but like on the highway, they've been cutting all these trees. Like, I guess they're trying to expand the road, but my allergies are so bad that like the smell of the trees were like sipping into the car, even though my windows were closed. And so I'm struggling breathing right now, just from all of that. Okay, so let me answer some more questions here. My brother is married to a US citizen. He got a 3-year green card. There's no such thing as a 3-year green card, so I'm going to assume you mean a 2-year green card. And now his wife has decided that she doesn't want to be married anymore. What can he do? That's fine. People get divorced all the time. As long as he had a good faith marriage, he can file for removal of conditions on that 2-year green card to get a 10-year green card. But the divorce has to be completed. The divorce actually has to happen. But more importantly, he has to have evidence that this marriage was genuine. That is always going to be the most important evidence, whether or not you're seeking a waiver, that this marriage was genuine. So your brother should continue and make sure that they've gathered a lot of evidence, especially evidence after they got that green card, to show that this was a good faith and genuine marriage. And again, for those of you who, if you find this information helpful and you want to schedule a consultation, definitely click yes in the comment and we'll DM you to find out more about your case and whether we can schedule a consultation. And you can always call our number. Your brother can call our number, which is pinned there, 678-325-1037, or you can book directly on our website, which is chinonwe.com/booking. Okay. Someone is saying, am I still eligible for naturalization? I married 5 years ago and I have a conditional green card. If I filed I-751 pending and ticked both joint and abuse waiver options, there's no such thing as joint and abuse waiver. Why would you do joint and abuse? That doesn't make any sense. So you're either joint or you're abused. I mean, I can see you going to go and amend your application to abuse, but joint means that you and your husband are coming together. So if you and your husband are coming together, why would you also tick abuse? So this is an example of where it's always good to hire an attorney so that you're not making mistakes. I would need a consultation with you to see exactly what is going on there. So if you comment yes, we'll message you to see if we can schedule. Is it normal to have a pending I-130 and I-485 since February of 2026? February 2026 was like 4 months ago. Of course it's normal. Like, you're in a normal timeline. You're absolutely in a normal timeline. These cases take a year. So you're good. Can you file adjustment of status while waiting for approval of VAWA, even if your prima facie is expired? Yes, as long as you are eligible for adjustment of status. So we would have to determine that you're actually eligible for adjustment of status, and the different things that we would have to find out about your immigration history, and your spouse's history, whether that person's an LPR versus US citizen and all of that, to determine if you're eligible for adjustment of status. Zig said, my cousin is asking me if it's okay for him to travel out of the country. He has a 2-year conditional green card. I told him I'll find out. Well, I don't know your cousin's immigration history, so I can't answer for your cousin. That said, if you have a 2-year conditional green card and you have not violated any laws in the United States, you don't have any criminal issues, and you don't have a contradictory I-751 application, you should be able to travel. But again, that is a general statement, not specific to your cousin, because I don't know your cousin's own history. Okay. Let's see what else we have. Some of these questions are repetitive, so I'm not going to answer them again. If I didn't answer your question, you can watch the live again and you'll probably find your answer there. If someone overstayed their tourist visa and married a US citizen, got the green card, do you think it would affect their N400 after the recent memo? Absolutely not. 90% of people overstay their tourist visas. The person already has a green card. The memo is for people who do not have a green card. So make sure you understand the difference. The adjustment of status memo are for people who do not have a green card, meaning they don't have a 2-year green card, they don't have a 10-year green card. N400, all they have to prove is that they got their green card properly. They are, depending on if they're doing a 3 or 5 years, they don't have any crime of moral turpitude. They have not traveled more than the required time. If they are eligible selective service, they they submitted, they basically registered for selective service. They are paying taxes if they owe any child support or if there's any child that doesn't live with them, that they're making sure that they're providing for that child. If it's going to be based on marriage, they want to show marital union, that they're still a marital union and they have to be living in the same place for an N400. But again, let me repeat, this memo has absolutely nothing to do with N400, which is for citizenship. You apply for citizenship because you're already a green card holder. This memo is for people who do not have US citizenship, okay? Is there no timeline on the pause? No. My valid case is 1,180 days. Can you divide that to me into years? My brain can't do that multiplication right now, and it's yet to be approved. Is there any way to expedite? Expedite will depend on what country you're from. It will just depend on what country you're from. But valid cases are taking about 4 years right now. Jan said, we love you so much. You're a true hero. God bless you. Thank you so much. I appreciate it. If someone I answered this one already. Like some of those questions are like duplicates. Can my husband get a work permit to work here before we change his status? This question is a little confusing, but the way it works is that something has to entitle you to a work permit. So if the question is, can he get a work permit before his adjustment of status is approved? Yes, but typically, if he is applying based on you being, i.e. a US citizen, filing for him, he will have to file an I-485 adjustment of status application first before he will become eligible for a work permit. And sometimes the work permit will be approved before the adjustment of status. I will tell you that right now, for a lot of marriage-based cases, we are seeing that those clients are scheduled for interviews even before their work permit is approved, because they're moving quicker with interview scheduling for those. All right, guys, again, comment yes before I log off live if you want one of my team to check in with you about your question and if we can assist you any further. Our number here again is 678-325-1037, or you can also dial 678-233-2170 to schedule a consultation. You can also book on our website. Link is in all the bios, Instagram, Facebook, TikTok, Google, whatever it is, Google, whatever it is. All right, guys, I hope you have a wonderful day. Again, a lot of you are wanting me to give you detailed analysis on your case. Schedule a consult. All right, bye.